Welcome to literary and jury charge practice. Let's get started with some jury charge. Ready? We have had no medical testimony of an affirmative character. The plaintiff tells us that she was taken to the hospital by somebody whose name she does not know, but the hospital records are not produced. She says she was in the hospital for a half hour, that she was instructed to bathe her face with witch hazel because she said her left cheek was swollen under her eye. She said that her left side, the left side of her abdomen, pained her. She said they bandaged it. Well, the hospital records have not been produced. She said she had a doctor, her own doctor, come to see her, and on his instructions she stayed in bed for several days. That doctor isn't produced because we are told he is in military service. She said she went to another doctor. She had a doctor call to see her once. He is not here because he is also in the service, she tells us. We have no testimony other than her own to the fact that she suffered pain in her left side and still suffers pain in bad weather since the accident, although she was in good condition prior to the accident. She tells us that she had a bill of $80 from one doctor and she paid $82 to the other doctor. Then she tells us she also was instructed to have some x-rays taken, and we had the x-ray expert testify. He tells us that while he took some x-rays back in December of last year and again in October of this year, all of those x-rays were negative. That there were no fractures, nothing pathological, nothing abnormal shown which would cause any pain. Nevertheless, the lady told him that there was tenderness in the left side of her abdomen. As I said, use your common sense and sound judgment. You should also bear in mind that the x-ray doctor said his bills for these x-rays were $60 and $40 respectively, a total of $100. If you consider that those x-ray pictures were reasonably necessary and that those charges are the fair and reasonable charges, you should have a right to compensate the plaintiff, Edith Sweeney, to the extent of the $100 and also to the extent of the other medical bills, the $20 and the $80 to which there was testimony, if you believe these bills were fair and reasonable. Now for some literary material. Back to Adventures with Ben Harold. Ready? Ben accepted the challenge, and John and I marked off the test and gave Ben a 2-voice 260 word per minute test for 5 minutes using John's stenotype machine, whereupon Ben immediately picked up his notes and reread it verbatim exactly to the word perfect. What an exhibition! I was shocked and impressed at the same time. Ben rose even higher on my A list that day. John was also impressed and became a student of Ben's theory. A few years later, Ben died, and John transcribed his notes on 4 or 5 appeals Ben had accumulated. John then gave the money to Ben's widow. For you students reading this, you too will meet many good reporters during your career. Some will astound you with their competency and efficiency. Learn from them. Keep the good things you learn and discard the bad things. Help and encourage others wherever you find them. Who knows, maybe one day you could make someone's A-list. Back to some jury charge. The subject of this particular jury charge is payment for services. Ready? Members of the jury, let me first commend you for the very careful attention that you have been paying to the testimony in this case and to the arguments of counsel. It is a rather unusual case. The plaintiff, Florence Doolin, is seeking a verdict at your hands against Agnes Rowland, administratrix of the estate of James Porter, deceased, the defendant. It is the contention of the plaintiff that she, a stranger not related to James Porter, rendered valuable services to Mr. Porter beginning in 1945 and up to March 19, 1956, when Mr. Porter died. That there was no payment in cash made by Mr. Porter to Mrs. Doolin during that entire period, about 11 years, that she did receive her board and lodging, but that she was promised by Mr. Porter that he would compensate her for her services by providing in his will for her. That, in general, is the contention of the plaintiff. She says that no will was found making any provision for her after Mr. Porter's death, and therefore she says she is entitled to receive from the estate of Mr. Porter, from the defendant in this case, the reasonable value of the services which she rendered in reliance upon the promise of Mr. Porter to compensate her by providing for her in his will. To substantiate her claim, she produces the testimony of a large number of friends and acquaintances of Mr. Porter and of Mrs. Doolin. It isn't necessary to review in detail all of the evidence submitted by these various witnesses, but it is sufficient to summarize that testimony with regard to the services rendered by Mrs. Doolin in the following brief sentences. It is admitted in the pleadings that beginning June 15, 1945, and up to February 1, 1946, the plaintiff, at the request of James Porter, acted as his housekeeper and cared for his sister, who was then ill and incapacitated. It is also admitted in the pleadings that $35 per week was the fair and reasonable value of the services rendered during that rather short period. Mrs. Doolin, according to the testimony, continued to act as the housekeeper in the various homes to which Mr. Porter removed from time to time. She did all of the housework, cooked, cleaned the house, did a lot of extra work in the way of taking care of apartments which were rented to tenants in the house, which they occupied as their residence, and also in the other house on 6th Street, which was owned by Mr. Porter, that was rented out. There is some testimony that she also helped in taking care of merchandise purchased by Mr. Porter in his business, that she helped to make that merchandise available. You had the testimony of Mrs. Lawrence, who said she was engaged in an employment agency. She gave it as her opinion that $45 was the reasonable value in addition to board and lodging for all of the services which the witnesses claim Mrs. Doolin rendered over the period beginning about 1952, when the 6th Street house was acquired. Now for some literary material, and this literary is called The Judge. Ready? It's not every day that you find yourself on a movie set with Robert Downey Jr. Last summer, my next-door neighbor, Molly McDowell, texted me that I needed to come out to the front porch. Boston Casting, she said, is looking for a real court reporter with court reporting equipment to be cast in a courtroom scene at the Plymouth Courthouse in the upcoming film, The Judge, and she wanted to send them my picture. All too often in films, you still see the mousy court reporter pecking away at an antique steno machine, striking one key at a time with a paper tape dribbling onto the floor. I liked the idea of shining a more realistic light on our profession, and especially so because I had recently updated to the Lightspeed Writer and the Microsoft Surface. Once Molly took the photo, I emailed it to Boston Casting along with a description of my writer and computer. A week or so later, Boston Casting informed me that I had the part. When I inquired as to whether I would be paid for my time, the casting director replied with a wink, "The food at the site is really great." The next step was to report to the wardrobe department in Allston, Massachusetts, and bring 3 outfits I would normally wear to work. The wardrobe department was housed in a gray brick warehouse that took up half a city block. Inside the warehouse were hundreds of rolling racks of clothing shipped from Hollywood, each rack labeled with numbers, scene names, and actors' names. I changed in and out of 3 different work outfits, and the staff took photos and sent them to the director. Ultimately, my gray pantsuit was given the okay, and it was tagged with a number and added to a rack. As I walked back to my car, I tried not to worry they'd lose my suit in the sea of rolling racks. that sounds like fun. Lucky court reporter. Let's get back to some jury charge practice. Ready? This is a suit in contract. Now there are various kinds of contracts. A contract, of course, is an agreement between two parties which imposes a legal obligation. It can be an expressed contract where one agrees to render services and the other agrees to accept those services and to pay for them. There you have an expressed contract. And there can be a contract implied in fact where there is no expressed agreement, but where the intention is clear from the conduct of the party. One renders services and the intention to pay by the recipient of the services can be reasonably inferred from all of the circumstances. That is an implied contract, a contract implied in fact. Then you have a contract which is implied in law, which is the kind of a contract that the plaintiff claims exists in this case. She does not say, and none of the witnesses say, that Mr. Porter ever expressly or implied agreed in fact to pay Mrs. Doolin the reasonable compensation for her services, but she says he did expressly agree that he was going to provide for her in his will so that she would be compensated for her services. And because he failed to provide for her in his will, because there is no will found which makes provision for her to compensate her for her services, she says the law implies, out of equity and justice and reason, that she ought to be able to sue the estate of the decedent for the reasonable value of her services. Therefore, the law implies a contract. Let's get back to our literary material. Ready? On June 27, 2013, I left my house at 6 a.m. and drove to the shimmering, modern Plymouth Courthouse, Plymouth High School complex. I was directed to the school building, where I was given a number and directions to the cafeteria to wait to be called for hair, makeup, and wardrobe. The high school was used as a staging area for actors, extras, gaffers, cameramen, construction people, lighting, and sound engineers. Breakfast at the Plymouth High School cafeteria was excellent as promised. I chatted with some retirees who frequently work as extras on movie sets for a little extra income. About half an hour later, I was called to hair and makeup, and after I was fixed up, I was sent to wardrobe, where I was reunited with my gray suit, and from there escorted to the courtroom. The film's director, David Dobkin, prefers to have real people play themselves in his films. For example, at the gorgeous, sun-drenched Plymouth Courthouse, there were extras dressed as uniformed bailiffs and court officers. There was also a set of authentic uniformed employees, bailiffs, court officers, and employees of the court. It wasn't easy to tell whether people were court employees on duty or were film extras. When asked for directions to the cafeteria or restrooms, actors and employees both replied as if they worked there. One person who fascinated me on the set was the continuity guy. He was the person responsible for making sure everything is the same from scene to scene and take to take. And that will conclude our literary and jury charge practice.